Hi, everyone. Good afternoon, and welcome to today's webinar presented by the Immigrant Legal Resource Center. Just a couple of housekeeping rules for today. As our presenters move along, and if they have an opportunity to keep an eye on the chat box, they will answer any urgent questions but we ask you to hold off on all your questions until the end. And I ask you to either use the Q&A feature or the chat feature. All questions will be kept track of, and I will do my best to share them with the panelists today. We have left about 20 minutes or so for Q&A, and any questions that are not answered will be followed up with. And with that in mind, I will now turn it over to the Immigrant Legal Resource Center panelists for our webinar today.
Great, thanks, Alonso. Hi, everyone. Thanks for joining us today for this webcast on understanding immigration options through family petitions. My name is Ariel Brown, and I'm an attorney at the Immigrant Legal Resource Center, a nonprofit based in San Francisco, California. And I'm joined today by my colleague, Veronica Garcia, who's also an attorney here at the ILRC. We appreciate everyone finding a quiet space, hopefully away from kids, pets, and other housemates to join us as we're all sheltering in place and adjusting to working in a very different environment in all meanings of that word. If we can move on to the next slide. So in the next hour or so, we're going to discuss the process of applying for a green card through family, including who can file a family petition and which relatives can benefit from this process. We'll also talk about what are the other requirements to apply for a green card based on a family petition. Lastly, we'll discuss why it's important to seek advice from someone who is authorized to give legal advice and how to find free or low-cost immigration legal services. As Alonso mentioned, we'll leave 20 to 30 minutes at the end for questions, but if questions come up as we're going through the presentation, we'll try to keep an eye on the chat box. So if we see there's confusion about something we're talking about, we'll do our best to clarify. So on the next slide, with that, I'm going to move to our first topic, obtaining lawful status. Next slide, please. So when we talk about lawful immigration status, what we're really just talking about is permission to be here in the United States for a period of time. That's it. Not all statuses include work permission or allow someone to leave the United States and come back. Some are temporary, like a visitor visa or student visa or work visa. Others are more indefinite and don't actually give a person status, but rather defer, in other words, postpone removal for a period of time. A form of deferred action that many of you have probably heard about and are familiar with is deferred action for childhood arrivals, or DACA. DACA provides work permission and protection from deportation in renewable 2-year increments. These immigration situations that are more temporary and indefinite don't have a direct pathway to a green card. A green card, also called lawful permanent residence or LPR status, as we'll talk about more in a minute, is a form of permanent immigration status, as the name suggests. And listed above green card on this slide is US citizen, which gives a person the most rights and protections, including being able to vote and, as you'll see, the ability to immigrate the most types of family members. So if we could go to the next slide. So a green card, as I was just saying, allows a person to live and work in the United States permanently, although they'll have to renew the plastic card every 10 years. It also allows a person to travel freely within the United States and abroad. A person can stay a green card holder forever, but green card holders can still be subject to deportation proceedings. So the most secure status is becoming a US citizen, which most green card holders can apply for after 5 years with a green card. Some can apply after 3 years if they're married to a US citizen. So becoming a US citizen is an optional additional step after becoming a permanent resident and getting a green card. So today we're just going to focus on getting a green card through family. So next slide. So there are various routes to get a green card, which I've divided on this slide into 4 main categories. In the middle is the starting point, someone who may be undocumented or who has DACA or temporary protected status or some other temporary visa. One of the ways to get a green card is through what we refer to as humanitarian forms of relief. These are immigration forms of relief like asylum, visas for victims of crimes, human trafficking, domestic violence, or other abuse. All these options include pathways to a green card. And also as a side note, people who have asylum or a U visa or some of those other humanitarian options that I mentioned can include their close family members, but that's different from what we're talking about today when we refer to family petitions. With a family petition, the person who is applying to immigrate their relative already has a green card or is a US citizen. So another main way to get a green card is through employment. Employment-based options can be temporary, short-term, with the possibility to be extended, or they can lead to a green card. And then there's also diversity visas, which are like a lottery for people who don't fall under the humanitarian visas and they don't have an employer or family member who can apply for them. To qualify for the diversity visa, you have to come from a historically underrepresented country that hasn't had high rates of immigration in recent years. Finally, there's family-based, which is one of the most common and what we're going to talk about today. Note that if someone is in removal proceedings, there's another option to apply for a green card through something called cancellation of removal, that if you win, not only are you not deported, but you also get a green card. But you can only apply for this green card option if you're in removal proceedings. So the ones on this slide are assuming you're not in deportation proceedings and you want to know some of the possible routes to a green card. And with that, I'm going to turn it over to Veronica to explain a little more about what the path to a green card looks like and when, and then she's going to provide an overview of family-based options.
Thank you, Ariel. Okay, so like Ariel mentioned, there are various paths to someone eventually obtaining a green card. When you think about the process by which someone can get a green card, you can think about it as a two-step process, which we'll go into more detailed throughout the presentation. Where this arrow here illustrates how someone goes from being undocumented to eventually an LPR. As you can see, that in order for someone to get status, they will need to first have a petition that will put them on the path, and then they will be able to apply for becoming a green card holder. For today's webinar, we are discussing the process through a family-based petition. So here, the second box where it says immigration option, it would be the family-based immigration option, right? Having a family member who could file a visa petition for you, which will then allow you to apply for a green card. So now I'm going to go over an overview of what this process is and what it looks like. When people talk about family-based options or petitions, they are generally referring to the process of getting lawful status through a family member. This means that a family member who has lawful status is submitting a petition or sponsoring you, i.e. their relative. For someone to be able to do this, they will need to show immigration that they, i.e. the sponsor or petitioner, has lawful status that allows them to petition someone, i.e. the beneficiary, the person who's benefiting from their petition. In the family process, family members who are green card holders or LPRs and United States citizens or USCs are able to petition for certain family members. If someone is an LPR or a USC, they will need to show that they have the required relationship to the relative they want to petition. Unfortunately, not all family members qualify to be petitioned for, and immigration law only allows for individuals to petition their spouses, parents, children, and sometimes siblings. Note that who a person can petition will depend on the status the person has. We will go over this in more detail later, but just to note, for example, if a person is only a green card holder, they will not be able to petition their parents or their siblings until they become United States citizens. Also, as you can see from the table, the family-based immigration process does not allow for LPRs or USCs to petition for their grandparents, their aunts and uncles, grandchildren, nieces and nephews. There are limited situations where an uncle could file a petition for their brother, who happens to be maybe your father, and you were included in that petition as your father's family member. This can have benefits for you now, which we will discuss a bit more later. Also, included in this overview of the process, right, like I mentioned, the immigrating through family is a two-step process, right? The step one is having a family member file a petition for you, their relative, and the step two is a person filing to immigrate, i.e. getting their green card, right? That is, the relative submits the application for the green card. Note that there are two ways someone can do this, either through adjustment of status or through consular processing. We will discuss this in more detail later. Now I'm going to turn it over to Ariel to take us to the next one.
Thanks, Veronica. So now I'm going to delve a little more into who can file a family petition. As Veronica noted, who you can petition for depends on your immigration status, whether you're an LPR or a USC. So next slide. Okay, on the next slide, a U.S. citizen can apply to immigrate their spouse, their parent, as long as the U.S. citizen is at least 21 years old, their child, or their siblings. And again, to apply for a sibling, the U.S. citizen must be at least 21. Children are treated differently depending if they are over 21 or married, but a U.S. citizen can apply for all these different family members: spouse, parent, children, siblings. Next slide. So you'll notice that who an LPR or green card holder can petition for is a lot shorter list. Someone who only has a green card can't petition for their parents or their siblings. They can only apply for their spouse and children. But as we mentioned in the beginning, someone who has a green card for at least 5 years, or in some situations 3 years, can apply to become a US citizen. And then once they're a citizen, they could petition for their parents or siblings. Something else important to note, if we could just go back to the other slide for a second, is that for children, if an LPR or green card holder wants to petition for their children, that child must be unmarried. If their child is married, they can't petition for them. And if the child already had a family petition from before they were married, they would lose it once they got married. Okay, next slide. So immediate relatives is this subset of relatives that get special treatment under the immigration laws. So who is an immediate relative? Immediate relatives are certain close family relationships with US citizens. The three types of immediate relatives are a minor child of a US citizen. The child must be unmarried and under 21. The spouse of a US citizen, or the parent of a US citizen. And for a parent, the US citizen must be at least 21. Okay, next slide. So here are some examples of immediate relatives. Izzy is 19 and undocumented. Her father, who had a green card for many years, recently became a US citizen. So Izzy is an immediate relative. Or another example, Charles is from France and he recently married a US citizen. So Charles is an immediate relative as the spouse of a US citizen. Or suppose we have Daniela, who's a US citizen. She was born here in the US and she just turned 21. Her parents are undocumented, and Daniela's parents are immediate relatives as the parents of a US citizen who is at least 21. Next slide. So I mentioned that immediate relatives get special treatment. One of the main benefits of being an immediate relative is there's no wait list to apply to immigrate. So they only have to wait the amount of time it takes to process the application. For other non-immediate relatives, called preference categories. After a family member files a petition for them, they have to wait years, sometimes even decades, in a wait list before they can finally apply for their green card. Remember how Veronica explained that this is a two-step process to get a green card through family. First, the family member files the petition, which is just a type of immigration application. And then when they are allowed to go on to step 2, the application to immigrate, the immigrant submits another immigration application that's the actual green card application. So next slide. So if you're not an immediate relative, the spouse, minor child, or parent of an adult US citizen, then you're in what's called the preference categories. Some of the other types of relatives who fall into these categories are spouses and children of LPRs, adult and or married children of US citizens, and siblings of US citizens. These people are divided into one of 4 categories based on the type of relationship. So for example, spouses and children of LPRs fall under what's called second preference. Exactly how long the wait list is for people in the preference categories depends on their relationship. Are they the spouse of an LPR or the sibling of a US citizen, and what country they're from? So we're not going to go into too much more detail on these preference categories, but the wait lists are updated and posted every month online in what's called the Visa Bulletin. You can Google it to see roughly how long the wait list is for someone to immigrate their sister from India or their adult son from Germany. Many of these wait lists are discouragingly long, based on limits on the number of people who can immigrate at a given time from a given country. And these long wait lists are one of the things that people point to when they say our immigration system is broken. But it's possible that while someone is waiting on one wait list, maybe their spouse who applied for them becomes a US citizen, and then they would be upgraded to immediate relative and move off the wait list. Or someone else might be able to file a different family petition for them that might have a shorter wait list. So next slide. So to give you a sense of how long the wait can be in the preference categories, let's look at an example. Sandra's father, who has a green card, just filed a petition for her to immigrate yesterday. Sandra's from Mexico, is 22 years old, and is single. Her wait to immigrate will be about 22 years. That's not a typo. So in 2042. That means that the petition that he filed for her yesterday might be approved relatively soon, but she can't proceed to step 2 and file her application for a green card until she gets to the front of the line, which will take over 20 years. This month, April 2020, immigration is saying that people like Sandra, who have family petitions as adult unmarried children of LPRs from Mexico, will have reached the front of the line if they were filed back in December 1998. Something else important to note is that, remember we said an LPR can only petition for a child who is unmarried. So if Sandra gets married while she's waiting those 22 years, which would not be outside the realm of possibility, she will lose her ability to immigrate through this family petition. So people like Sandra, trying to deal with this challenging situation without putting their lives entirely on hold, will sometimes live with a partner, have children with them, and build a life together, but without legally getting married, so they don't lose their ability to immigrate through a petition like this, filed by an LPR parent. Next slide. So just to show you that it's not all gloom and doom with preference family petitions, let's look at another example. So Maria, who's from the Philippines, has a family petition through her LPR husband. This month, there is no wait list for people in Maria's situation, so she can apply for a green card as soon as her family petition is approved. These wait lists change from one month to the next, though, so it's possible that if she waits until May or June to apply, a wait list may develop for her category, so it's best to apply as soon as she can. Next slide. So this is a brief summary of some of the main advantages and disadvantages of being an immediate relative versus in the preference categories, what we call preference beneficiaries. So as we already talked about, immediate relatives aren't subject to a wait list, which can be a huge benefit, given that for others, the wait can be many, many years. But one disadvantage of being an immediate relative is that someone who's immigrating through an immediate relative family petition can't include their spouse or children. An example would be Daisy, who's 20 years old, lives outside the United States, and has a baby daughter. If Daisy's father were a US citizen and wanted to petition for her to bring her to the US to live permanently, Daisy couldn't bring her daughter with her, and there's no family petition for a US citizen grandfather to apply for his granddaughter. So she would have to immigrate first, then turn around and apply for her daughter. So one main advantage to being in the preference category is that these immigrants can include their spouses and children on the same application and bring them with them. But the big disadvantage, as we already talked about with preference beneficiaries, is the very long wait lists in some categories. Next slide. So one other thing that I want to mention about family petitions before I turn it back to Veronica to talk a little bit more about the process of applying is that when a spouse is the person filing the petition, these types of family petitions are scrutinized more closely. Because apart from adoption, this is basically the only family-based immigration option without a blood relationship. Immigration officers look more closely at these relationships to make sure they're not fake, what's called a green card marriage, where the only reason the two people are getting married is to get one person a green card. So in addition to proving the legal relationship by providing a copy of their marriage certificate, the couple must prove that it's a real marriage. So for immigration purposes, a real marriage is one where both people intend to establish a life together. As long as at the start they plan to share life together, it won't be considered a sham marriage if things don't work out and they later end up divorcing. A real marriage doesn't mean that it has to last forever, just that when they entered into the marriage, that was their hope and plan. So immigration officers will look at things like whether they have joint bank accounts and jointly filed taxes, live at the same address, have children together, etc. None of these things are absolute requirements, but the couple has to convince immigration officers that they didn't just marry to get the non-citizen a green card. And now Veronica is going to briefly describe the application process for someone seeking a green card through a family petition.
Thank you. So now I will briefly cover what the application process looks like for many of these petitions. And note that we are not going into details and will not cover all the nuances of the process, which can be really lengthy at times and require a lot of supporting evidence. Like we mentioned before, the process of obtaining lawful status is a two-step process. Step one, the family member who has status and can petition for you files a visa petition for you. They're a qualifying relative. This process is pretty simple and straightforward. They will just need to prove that they have the status, right? Either by submitting a copy of their green card or naturalization certificate or birth certificate if they were born here, and show how they are related to you. Are they married? Are you their child? Are you their sibling, etc. Step two is a bit more complicated and can take a very long time for certain people. This is a step where many people often get stuck and are unable to complete due to some requirement they cannot meet. This is a step where the person who has been approved will apply to become a lawful permanent resident and immigrate to the United States. Or if they are already here, to stay lawfully. At this stage, people's petitions will be processed through two different entities depending on their particular circumstances. They will either go through adjustment of status, which essentially means the person is able to complete all their paperwork, their interview, and other requirements within the United States, or through consular process, which means the person will have to complete this process from their home country and interview with the consulate abroad. Also, just to note, this is demonstrated as a two-step process because most people will need to complete the first step and get a visa before they can complete step 2. The wait between step 1 and step 2 will differ for all. People cannot complete the second step until a visa is available. And like Ariel mentioned, sometimes this is a long wait for certain people because of the preference category they fall into. For immediate relatives, this will not be the case because there's always a visa available for them and they essentially can complete both steps at once, or as immigration individuals say, do a one-step adjustment if they're able to do it here. So as illustrated by this arrow, which you have seen before, now you can see that the process for getting legal status through a family petition is the following, right? So the person who is undocumented or has another form of temporary status will have a family member who has status, an LPR or USC, file a petition on their behalf. The second box in this arrow shows this. This step is completed by the family member who is the LPR or USC, right? So if you're being petitioned, you would not complete this step. Your family member would do this step. After this happens and the visa is given, the individual is able to submit their application to get a green card. That is the third box in this illustration. This step is done by you, i.e. the person being petitioned or the person asking to get status, right? So the undocumented individual who now wants to get a green card. When you're applying to immigrate, in order for someone to be able to complete the process, they will need to show that they have an approved family petition, right? That is that a visa, they submitted the petition, it's been approved, and now a visa is also available for them. For family members of US citizens, this will be almost immediate. For other, it will take many years for them to have a visa available for them. Once they have a visa available, they can move on to the second step, right? Because they're being the front of the line. At this step, they will have to show that they are admissible. That means that they don't have any disqualifications that will prevent them from getting approved, right? Nothing that will prevent an immigration officer from denying their green card application. Some of the most common things that keep people from showing they are admissible or that they qualify to be approved are certain crimes. People who have lived here in the United States for a really long time without permission, having entered multiple times without permission, maybe being caught at the border by Border Patrol, are things that could put roadblocks or make your application process a little longer. And lastly, once all the evidence and applications are submitted, individual will have to complete an interview with an immigration officer, right? And this is the part in the second step where, if you're adjusting status, you could do it here in the United States. But if you're going through the consular process, then you would have to exit the country, go to your home country and be interviewed by an officer there. Like I mentioned, right, the location of the interview will depend on whether the person is adjusting status or consular processing. Generally, if a person is living outside the United States when they apply to get status, they will complete their interview abroad at a U.S. consulate. Also, a person who is living in the United States but did not come into the country with a visa or meet any of the other requirements that would make them eligible to adjust will also have to complete their interview abroad at a U.S. consulate. We will go over the other possible ways someone might be able to avoid traveling abroad, further process in the next slide. On the other hand, people who are living in the United States and enter with a visa or some permission are able to complete their process in the country. That is, they will not have to travel abroad to be interviewed by an immigration official. They will be able to do that here. This is often preferred because this means people will not have the expenses of traveling abroad. And it also at times prevents someone from triggering some of those disqualification grounds or inadmissibility grounds that might prevent them getting approved. Note though that I am reviewing this very generally and people should speak to their legal representative about all the nuances when they're completing their process. This is very broad strokes of who and when this process would take place. All right, so really quickly, if you're getting ready to apply, or you know someone who is getting ready to apply, it's really important to note if they would fit into any of these categories, because it could change where they are completing the process. It could also change whether maybe they would be eligible to get a green card or not, depending on their specific circumstances. Generally, right, for someone to be able to adjust, they would have had to enter with the visa, right, either a tourist visa or a student visa, to be able to complete the process here, right? There are other ways you can meet this requirement, so that you're able to adjust here in the United States. So it's important to explore and see if you fall within any of these. Excuse me, so some of them are having an older petition, right? So if you have a petition that was filed before April 30th, 2001, if you fall into this category, then you're considered to have 245, to be 245I eligible, which means that you are protected and can complete the process in the United States, even if you entered without a visa. It's important to ask parents if they have ever had a family member submit a petition for them and you were included as their child, or possibly to see if any other family members like your parent or maybe a former spouse filed a petition for you prior to this date. This protection allows you to use this older petition to complete your process here in the United States. For this, you want to make sure that the petition was valid and approvable when it was filed. You know, this means that the family relationship existed that allowed for this type of petition. And this can get kind of complicated, and there's a lot of little nuances you want to take into consideration. So I just want to note that when you or a family member or someone you know is talking to a legal representative about their case, make sure to mention and disclose if you have an older petition, whose petition it was, what was your relationship to the person who petitioned, right? Was it for yourself or a family member? What was the date that the petition was filed? And if the relationship still exists or if it doesn't, right? So if it was a spouse, you now divorced, when that divorce happened, did you guys get married before maybe their petition was filed or your petition was filed? All this could make a difference, so you want to make a note of that. Another way that could help someone adjust here in the United States is traveling on advance parole. This is most commonly seen or was seen with DACA recipients, though just to note, DACA recipients are not eligible to apply for advance parole anymore. So if you hear of anybody saying that someone told them they could, please tell them they cannot, because they're no longer able to do this. It's also seen with TPS holders who are able to apply for advance parole to travel abroad. So advance parole essentially gives someone permission to travel outside the country, and then they are paroled back in. Being paroled back into the country allows someone to meet that initial threshold requirement to adjust status. So even if they originally didn't come in with a visa and were fortunate enough to travel on advance parole, as a DACA recipient, and now they're married maybe to a US citizen, then it's great because now they could do their process here in the United States and avoid all the complications that might come with consular processing. Also, just to mention quickly, TPS holders in California and as well as other states, limited states, not every state, unfortunately, could potentially use their TPS as an admission, right? Therefore, being able to adjust status. So if you're a TPS holder or someone who is a TPS holder, they would definitely want to explore that with their legal representative to see if it would allow them to adjust status. Lastly, if you came in through a border checkpoint, right? A lot of individuals came in a car when they were really young, and they were possibly like sleeping, or they didn't exactly know what's happening at the moment and were essentially waved through at the border by a border patrol, a CBP individual. They could potentially use this to show that they were admitted into the country, right? Therefore, they can adjust status. That would be a little trickier to prove, right? Because you would have to show them that this in fact happened, and details around what and when it happened. But it definitely has been used before in the past. So if you know of how someone came in, or if you don't know if how someone came in, or you yourself aren't exactly sure, it's really great to explore that with either family members or parents to see if you would qualify for this. Each of these will require proof and are very case specific. All right, so they can generally just be applied to everyone. And I didn't go into a lot of detail, but I wanted to mention them in case you know of someone who might fall into one of these groups, or you yourself will be able to benefit because you fall into one of these groups. It's important when you are ready to apply for lawful status through a family member to mention these things if there are facts that are relevant to you, right? Because it can change your eligibility, like I mentioned. It could also prevent you from having to leave the country, and immigration law is really complicated, and complex, and something as simple as leaving a country could definitely change if someone would be able to adjust or not. So it's definitely worthwhile to explore. Okay. So sorry to sound like a broken record. I know I mentioned it a lot that when you seek legal representation, right? But it's really, really important that whenever someone's getting ready to submit an application, either through family-based options or maybe a humanitarian-based option like Ariel mentioned in the beginning, or employment, or any of those others, that you seek legal representation. Immigration law is complex. It's crazy. Policies change, especially now policies are changing rapidly, it seems. So it's good to get immigration help whenever you are ready, right? Because there are a lot of issues and specific facts and rules that need to be discussed in detail with someone who knows the law and the process to ensure you are not putting yourself at risk, right, of being denied or potentially being removed, or if you have to travel abroad, at being stuck in your home country after you exit for an interview, right? I'm going to go over some of the issues to watch out for in the next few slides. These are not, a complete list, and they don't state a lot of details of what would make you fall into any of these particular situations or categories, but definitely wanted to flag in case something sounds familiar for you or someone you know, that they make sure that they watch out for these things as they move forward. Okay, so just something to keep in mind when you're discussing with your legal representative about your case is your immigration history, right? So immigration history could definitely change how someone is eligible for something, or it could change which type of applications you could submit or not submit, right? Which type of pardons or waivers, as they're known in immigration law, you would need to ask for as you move forward, right? Some of the common things in immigration history that you want to be on the lookout for, or you want to tell people to be on the lookout for, is, have you been ordered removed before, right? Were you ever before an immigration judge and you left and you came back at the border when you were attempting to enter? Were you detained, right? Were you removed? Did you sign anything? These facts can make a case more complicated, and it's important to see how they would impact eligibility before you move forward. Really, really, really important to be honest about these facts as you move forward with cases. Some of the other issues, right, you want to discuss is, or that could impact someone's case, is have they been living in the United States without status, right? Do they have any criminal convictions? Did they enter without permission? All these things could determine where you're able to complete your application, right? So if you entered without permission, like we mentioned, you came in with not a visa, or you weren't, paroled in, you would have to leave and do your application through the consulate abroad, and if that, in combination with you having lived here without status for many years, that could trigger a potential ground that disqualifies you in some way or makes you inadmissible, right? And then that could mean that you need to ask for a waiver, right? It can mean that you need to see if you even qualify for this waiver. So it's important to keep in mind as you're working with family members, or you yourself are going through this process. And just to continue around that, right? Many people who have a family member who could petition for them, right? You know, beyond waiting a long time, these issues that I just mentioned could also prevent them from getting a green card, right? Many people, even though they have a relative that can submit a petition for them, will need a pardon for the second step because of some specific issues or facts. Here there might be a relative, here they might need for another relative to help complete the process. And sometimes people will not qualify for like a pardon through one relative, but maybe through another. A really common example of this is parents of USC children who entered without permission and have been here unlawfully for many years. In their cases, these parents will have to leave to complete their process at the consulate abroad because they entered without permission. The problem is that once they exit, they will trigger an inadmissibility ground or trigger something that would disqualify them because they've been here unlawfully, right? And once they leave, then all the time they were here unlawfully would be counted against them. Here they would need to get a pardon or a waiver, but unfortunately children cannot help them get this waiver. You know, if they have another family member who might be able to get the waiver for them, then great, but many people don't, so then they're kind of stuck in this limbo, so definitely worth mentioning and exploring. And then it's because of these particularities and issues that we strongly encourage people to get a legal consultation. We understand that many people have previously gone and gotten a legal consultation and they were told that they didn't qualify for anything, so then they haven't gone since, right? But I just want to mention that just like we go to the doctor every year, right? Because our health changes, you know, maybe we lose weight, we gain weight, we suddenly develop allergies and asthma, right? That will change what kind of diagnostic the doctor gives us. It's the same thing with immigration law, right? Maybe 5 years ago, when I started applying for DACA, I didn't have a family member who could petition me, but now, you know, I was able to travel on advanced parole. I was fortunate, you know, I married the love of my life, who's a US citizen, and now those facts have changed. So now maybe I'm eligible to petition, right? So you always want to go back and see if the changes in your life could possibly have opened some opportunities for you. You know, also, even we're not discussing it in this training, right? There's also the possibility that if something happened, right? So if you were the victim of a crime, right, maybe you would be able to qualify for some of the humanitarian grounds that Ariel mentioned in the beginning. So you definitely want to go and talk to someone. Also, it's really important to get a second opinion. So if you go and you speak to someone and what they're telling you doesn't sound quite right, or maybe they didn't answer all your questions, or you just want to verify that the information you're getting is correct, you know, it's perfectly normal and even encouraged to go and talk to someone else and see, you know, what someone else tells you, because this is about, you know, this could change the life of someone and like change where they're living essentially, right? So you always want to make sure that the information that they're getting is correct and, you know, and that their questions are completely being answered before they decide to either submit a petition or move forward. And they could weigh their options. Immigration law is really complex, like I mentioned, so you definitely want to get help as you move forward. And then we understand that could be really expensive to go talk to an attorney, right? Private attorneys sometimes charge a lot, even for just a consultation. So I just wanted to let you know that there are free and low-cost immigration legal assistance available to you. The first link that appears on this slide is for a national legal directory. What's really cool about that one is that you can input your zip code, right? So I, who live in the Bay Area, would put my zip code in. Then I would get organizations who are here, you know, either in Oakland or San Francisco or Berkeley. And then it would tell me what types of services they offer, right? Do they only do DACA applications? Do they only do family petitions, right? Do they only do U visas? So then from there, I could go and call the agencies that will be able to answer the questions for the type of application I want to submit. The second one is a list of selected California immigration legal service providers through, the CDSS from the California offers a list of organizations that are able to give you immigration advice and services, right? The good thing about this list is if you know of any DACA recipients, some of these organizations are able to provide fee assistance. So it's really good to check out and see if they have funding to do that. Just because we know right now, especially right now, a lot of people have stopped working. So it might be good to get that help in, and then also just gives you information of other organizations. And then lastly, on-campus resources. A lot of campuses now have legal support through different nonprofit organizations, right? A lot of campuses have undocumented student centers, right? So they might be a great resource to look into and see what type of services are available locally for you to access. And also it's a great way to know who to trust, right? Because there's a lot of people doing immigration law right now. You would want to go to someone that's trustworthy. And with that, we just want to say to watch out for fraud. Immigration law is complicated and it's changing. In the past, a lot of businesses in the community would help individuals file immigration petitions, and some of them are really, really good. Some of them are not really, really good, right? But we just want to note that you should seek advice from someone that's trustworthy, right? And to note that here in California, there's only 2 types of individuals who could actually give legal advice, right? So that's beyond filling out a form. To actually tell you if, based on the facts of your case, you would qualify for something. That's an attorney or an accredited representative, right? Attorneys could be barred anywhere. They don't have to be barred here in California, but they definitely have to have a license to practice. So it's always good to Google and see what comes up from someone, right? Also accredited representatives, they're, accredited through the Department of Justice. They have to be affiliated to an organization. So you want to make sure that you look out and see that who they're affiliated to and that they're actually allowed to continue to give legal advice, right? Some people may have been affiliated in the past, but now no longer are with that business. So you want to look into that. And then lastly, it's complicated and sometimes you're unsure of what a legal service provider should do for you or what you can expect when they take your case. When someone's looking and taking your case, they have to provide you with a contract, right? And receipts for any payments you give them. The contract should outline exactly what type of service they're doing for you, right? Are they only going to represent you on this one case, right? Are they going to submit maybe the first step, the visa petition, right, that your family member does, but not help you with the green card, right? So things like that, you want to make sure you discuss. And also they should explain the process and answer any questions that you have. If they're not answering your questions, then something is definitely off, right? Because it's your case, it's your right to be informed throughout the whole process. And lastly, they should follow the rules of the application and immigration law as it goes, as well as the rules of how they're representing you. Okay, so that was our overview of a family-based immigration petition. Before we end today, we just quickly want to go over this other form of relief because of its similarities to a family-based immigration options, just to make you aware of them. Right, so the Violence Against Women Act, VAWA self-petition process was created to help individuals who could have been petitioned by a family member, but maybe that family member didn't do it because they were holding that person's immigration status against them, right? Or as a power play. Maybe there was like abuse in the household, right? And they always said, oh, I'm going to do this family petition for you, but never did, or always threatened to call immigration on the person, right? We understand that these situations exist. So even if you have a family member that could potentially petition for you, it doesn't happen, right? So what is VAWA? So VAWA allows the abused spouses and children of lawful permanent residents and U.S. citizens and the abused parents of U.S. citizens sons and daughters to petition for themselves independent of the abuser. So as you can note, who is able to submit a self-petition is similar to who was being petitioned in the family process we explained, right? So a US citizen, right, was able to petition for their spouses, their children, their parents, right? A permanent resident is able to petition for their spouse and their children. So here it's the same, right? If the abuser was an LPR, then I as the spouse or the child could petition for myself, right? There's similarities, there's also some differences that make this process a bit more friendlier, but we're not going to go into all the details. We just wanted to make you aware that this also exists. Right, so who is eligible? Abused spouses of LPRs and USCs are able to self-petition. If you are not abused, right? So if I'm married to an LPR and a USC, but I wasn't being abused, but my child was being abused by this LPR or USC, then even if I'm not being abused, I could petition. I could submit a self-petition. Also, abused children, right, of LPRs and USCs could submit a petition, and then abused parents of USCs. So here I want to note, right, that just like in the family process, parents were only able to get petition if their USC child was over 21, so if they were an adult, and here it's the same process. So what are the requirements for you to be able to do a self-petition? Just like in the family process, you have to show that there's a family relationship, right? How are you related to them? Just like in family, if you're doing it through a spouse, you have to show that you are married, right? Lawfully married, and that you were married for other reasons, not just for the green card. The abuser has to have status, right? They have to be an LPR or a USC. Different than the family process, right? Here you have to show that there was battery or extreme cruelty, right? So either to yourself or to your child. So here you would have to show what type of abuse you were experiencing, right? Was it mental? Was it physical? It doesn't have to be one or the other, right? It could be a combination of both. It could be the abuse you suffered for many years, right? And they also take into consideration like what the history, right, that you have as an individual, and how that triggered and made something maybe more extreme within your relationship now, right? So if in the past I have always suffered domestic violence from parents or siblings, maybe now that I'm in this relationship, the domestic violence I'm suffering could be, exacerbated, right? Different than family, I will also have to show that I'm a person of good moral character, right? So I merit this, right? I am, someone that will make my community better in essence, right? So you would submit evidence around that. And also I have to show that at one point I resided with the abuser. It's okay that I'm not residing with the abuser now, but at some point I have to have. And then, just family relationships. Spouses are people who are legally married, right? So you were lawfully married and you have a certificate to show that. Good faith marriage, like I mentioned, you have to show that you married for other reasons, not just for the green card. For a child, in immigration law, a child is anyone who's under 21. I just want to know for BAWA self-petitions, children would be considered up until the age of 25, right? So if you didn't submit by 21, but there was abuse and maybe that abuse prevented you from submitting the petition, then you have up until you turn 25 to submit your self-petition based on abuse from a parent. And then the parents, abused parents can self-petition when, like I mentioned, their child, US citizen has to be over 21, just like in the family process. So just really quickly, good faith marriage, right? You're not together just for the sole purpose of immigration benefit, right? Just not for the sole purpose of getting a green card. It's fine that you were married and that was something that, was always going to happen, like they were going to petition you. But that can be the only reason, right? You have to show that you actually got married because you wanted to build a life together. The marriage has to be valid in the place of the ceremony took place, so it's fine that it didn't happen here in the United States, right? The United States recognizes marriages from all over the world. Just as long as that happens, it's valid there, right? And then for common law marriage, right, it allows for people to self-petition if it's recognized where the ceremony happens. So here in California, we don't recognize common law marriage, but I know other states do. So definitely look out for that. Just really quickly, the process, right? The VAWA petition could also be thought as a two-step process, just like the family-based petition. Here, instead of the petitioner being, the lawful permanent resident or the USC, you would be submitting a self-petition. That would be step one, right? Once you submit that first step, individuals usually get a receipt notice and a prima facie notice saying that they think they're going to be approved, right? This means that enough documentation was presented, right, to show that you met the requirements, to show that you're eligible. And this allows you to be eligible for certain public benefits. Also, just a note, I know there's been a lot of talk about public charge, right? VAWA self-petitioners don't have to worry about that. Once the VAWA application is approved, then individuals, depending on, whether their abuser was an LPR or USC, could complete the second step of getting a green card. If it's an immediate relative, you could potentially do that in one step. If it's an LPR, you might have to wait for a visa to become available for you to complete the process. The good thing is that while you're waiting, and you get deferred action, right? So you get protection from being removed, and you also get a work permit so that you're able to work lawfully while you wait, and you could extend and renew your work authorization and your deferred action while you wait for a visa to become available. Okay, so I think with that, we are done, and we will turn it over to questions. I don't know if Ariel wants to add anything else before we finish.
Sure. So I was just going to address some of the questions that I saw in the chat box earlier, but everyone please feel free to submit more questions. We've reserved this entire last half hour for questions about some of the things that maybe we didn't get to or that you want to follow up with. So just to start with some of the questions that I already saw, Lorena was asking about, so if a child, for instance, of a permanent resident or green card holder has to be unmarried to qualify for that family petition, what happens if they divorce? So generally that would be okay. It doesn't mean that the child has to have never been married. They just must be unmarried when the petition or for the purposes of that petition. And same with marriages where someone can't just marry for an immigration benefit or a green card. It's okay if they divorce as long as they're not just divorcing for immigration purposes. So if someone was the child as an under 21, so maybe they were 20 of a permanent resident and they got married, and then they found out that would make them lose the petition and they divorced just for that one reason and still intended to, for all other purposes, basically still live with this person as their partner, that might not pass muster. But otherwise, just divorcing returns you to that status of being unmarried. And then another person asked about, while people are on these long wait lists that can last for many, many years, is it okay for them to visit? So if they're outside the United States and waiting. And so the general answer is yes. If they get an approved visitor visa or they maybe have a border crossing card. But it's important that they communicate to immigration officers whenever they are trying to travel to visit on that, visitor visa, that they intend to just visit and then they will leave, because immigration is always paranoid that someone is going to come for a quote unquote visit and then never leave. So they have to make sure to convey that they intend to comply with the terms of the visitor visa while they wait out, however long it's going to take to actually be able to immigrate. And immigration officers may not believe the person and they may not let them in, but they certainly can try. And they should always be honest and truthful about whether they have a pending application to immigrate. So they should never lie about that. You want to go ahead?
A follow-up question on that. If a person has been in the United States for over 30 years and were entered legally and were once granted temporary protected status, what kind of relief options do they have? And this individual was also the daughter of a U.S. Has a daughter that's a U.S. citizen.
Okay, so having temporary protected status, as we sort of very briefly touched on in the beginning, right, does not have a direct pathway to a green card. So, you know, they would be looking for an employment option or a humanitarian option or a family option. So here it sounds like they might have a family option because they have a daughter who's a US citizen. That daughter must be at least 21. And then she could submit a petition for the parent who has TPS. And if they live here in California or any of the other states that fall within the Ninth Circuit, which is like a lot of the West Coast, Alaska, Hawaii, if you live in any of those states, as Veronica mentioned, simply having been granted TPS is sort of the same thing as having entered with a visa. It means that you can do the entire green card process and the interview here in the United States. But as we also talked about, when a person moves on to step 2, so after they have the family petition and they're ready to apply for a green card, they still have to show that they're not disqualified, you know, for having any sort of crimes or any of the other list of disqualifications. So don't just take what we're saying right now during this webcast as your complete legal assessment. As Veronica said, you know, that this person would still want to meet with a immigration attorney or accredited rep.
And what happens if someone petitions for an individual and the person that submitted the petition is now deceased?
Oh, that's a great question that I guess we didn't really touch on. So there are some protections if the petitioner passes away. There's a provision of the immigration laws that says that as long as the beneficiary, the person who was hoping to immigrate, was living in the United States when the person who filed the petition for them passed away, they can still proceed with the application. So it's sort of an unfortunate quirk of this section of the law that if you were living abroad and maybe your parent filed a petition for you and then the parent died, you wouldn't be able to benefit. There's another area of the law that's much more discretionary, where you can ask them to reinstate the petition. And so maybe someone who doesn't fall under that more general provision of the person was in the United States when the petitioner died might still be able to benefit from this other discretionary thing called humanitarian reinstatement. Yeah.
Thank you. That's a great, I think that's top of mind for a lot of individuals.
Yeah. Yeah, right. Especially when you're waiting like 20 years, a lot can happen in that time.
And you know, how long is too long for an unlawful presence?
So in general, if you have more than 180 days of unlawful presence, so 6 months, and then you leave, that is a 3-year bar to being able to immigrate. And then if you have a year or more, then it's a 10-year bar. But the periods of time that you count up for unlawful presence are kind of complicated. If someone is under 18, they don't accumulate unlawful presence. Also, while someone has DACA, they don't accumulate unlawful presence. And so there are some other scenarios too. So that's like another thing that you might need a legal representative to help you calculate that.
Great, thank you. And a parent who entered unlawfully into the country and now has a child over the age of 21, that child can now petition the parent? Yeah.
So the first step, the family petition, is like, as we were kind of trying to explain it, it's actually relatively straightforward. You just have to show you have someone with immigration status who can petition for you and that they have that qualifying family relationship. So do you have a US citizen or permanent resident, spouse, parent, child? If the person is a US citizen, it can also be a sibling who could submit a petition for you. And then as Veronica was talking about at the end, if you have any of those relatives but they're abusive or they're, you know, exerting control over you, and sort of holding you hostage for your lack of immigration status, you can go ahead and sort of step into their shoes and submit the petition for yourself. Step 2, though, the applying for a green card, is where it gets more complicated and sort of the process diverges depending on if you entered with a visa or not, or if you fall under any of the other things that Veronica tried to just highlight. Like if you have that really old petition filed before April 30th, 2001, there's like a special provision of the law that might help you in some of those other situations too.
Thank you. And can you elaborate a little bit more on the 601 waiver if the petitioner is a 19-year-old unmarried USC child and the undocumented parent enter the country unlawfully?
Sure. So I see the question actually here in the chat box. So one thing is, so it says the petitioner would be a 19-year-old unmarried U.S. citizen child. So the U.S. citizen child has to be at least 21 before they could petition. So there are no 19-year-old U.S. citizen petitioners, but in a couple years, then they could petition for an undocumented parent. And yeah, if that parent entered the country unlawfully and they don't fall under any of those other sort of special circumstances, like having that old petition that might allow them to process here, or not having TPS, or not having travel with advanced parole travel permission. So if they didn't fall under any of those situations, then they would have to leave the country and have their green card interview at a consulate abroad. And when they leave is when you trigger these unlawful presence bars. So you can be living in the United States for 20 years unlawfully, and you still don't have an unlawful presence bar until you leave. So that's another reason why when Veronica was talking about how important it is that you get legal advice and then maybe even a second opinion, I would say, especially if someone is telling you, oh yeah, this is going to be really easy, you know, just leave the country, you'll have your interview, you'll be back in a week. You just want to make sure to really double check, because you don't want to be stuck outside the country if they miss something. And so that 601A waiver that the person who's asking this question is asking about is one of these pardons for one of the disqualifications for getting a green card for unlawful presence that you can apply for before you actually leave for your green card interview. So you basically are saying, I know when I leave, I'm going to be triggering this bar. So I want to ask for it in advance. That way, this whole process will be a little more quicker. Otherwise, you leave the country, you go to your green card interview, they tell you you need this waiver and you have to stay out of the country for 8 months or longer while they decide that waiver application. But this 601A waiver, you have to, unlawful presence must be your only issue. And so, especially with public charge that some of you might be aware of becoming this new problem that is really hard to anticipate in advance whether or not you might be found inadmissible for public charge. It becomes a lot trickier to apply for this waiver before you leave. So this is another thing that just really requires help from a trusted legal service provider.
Thank you. And we'll go back to question about divorce. If a person was married for 5 years, now has 3 children, but they're going through the divorce process, can they still file? Or what kind of relief options would they have?
So I think I see the question. It's from Josefina, is that right?
Mm-hmm.
Okay, so if a person was married for 5 years, and so the person that we're talking about is undocumented? I'm just wondering, what is the immigration status of the person we're talking about? Yes? Okay. And so their spouse had some kind of status and their spouse filed a petition for them? Is that the question?
I think so.
Okay.
But now they're going through a divorce?
Uh-huh. Well, so once they're divorced, they're no longer legally married. And so they don't have that family relationship anymore of marriage. So they're not going to be able to immigrate through that relationship, which is, you know, been terminated with a divorce. The only exception to this rule in terms of, I see that question, they also say the petition was never filed. If it was never filed because of some sort of abuse or domestic violence situation, like Veronica mentioned, in that situation, I mean, Veronica, correct me if I'm wrong, but I think you have like 2 years after the divorce to file the petition for yourself. Is that right?
Yes, that's correct. Yeah. So if they were,
Mhm.
if there was any abuse, and that now they're, you know, they've divorced them, let's say yesterday, right? They have 2 years from yesterday to submit the petition under a BAWA.
Mhm. And then otherwise, in terms of what other relief options, going back to one of those really early slides, we were trying to sort of lay out that overall landscape in terms of not, I guess we really were talking about options for a green card, which are primarily through family or an employer or these sort of humanitarian categories or the diversity visa lottery. But apart from those, which are all ways to apply for a green card, there may be other more temporary relief options, like a U visa or a T visa. So anyways, without knowing more details about their situation, it would be hard to say what this person's options would be.
No, as you know, you've mentioned immigration is a complicated issue. So if they have any further questions, please seek out a trusted legal service provider. And I will be sharing a list of available legal service providers for our students at community colleges and at the CSU. And then we'll also be sharing the list of trusted legal service providers from the Department of Social Services.
Mm-hmm. And, or one thing I just wanted to add too is, you know, because as we talked about the family petition, that first step is like relatively easy application. You just have to show, you know, you have this relationship with a person who has immigration status. And given the long wait lists, you know, often people just sort of want to file that first petition, you know, as soon as they can to secure a place in line, even as they're still sort of sorting out what is going to be their option at step 2 to apply for the green card. Is it going to be here? Is it going to be abroad? Maybe they don't even seem to have an option at this moment to apply for a green card, but if they still have that family member who can file a petition, because the wait lists are so long, it might be worth it to still submit that first petition. You can also have multiple petitions. So if you have a couple of family members and you maybe want to sort of bet on which one might move more quickly, you can submit more than one. The only thing that I would say someone should watch out for before submitting a family petition is, as Veronica mentioned, if they have a deport or removal order, because if you file that petition, you are basically giving ICE your address to find you. So that will be the only situation where you would not want to submit it. And if you're not sure if you have a removal order, because sometimes it's not always in front of a judge, it could happen at the border and you may not have known it was a removal order. That would be another reason to seek legal assistance, because a legal representative can help you look up your immigration history.
Great. Thank you for that. Lorena is asking about, is a student who's on a TD visa and wants to know if she qualifies under AB 540 status and if she can apply for the California DREAM Act. That might be more of a financial aid question rather than a legal question.
I mean, I don't know the answer to that. I don't know, Veronica, do you? Veronica knows a little bit more about like sort of the DACA and some of this DREAM Act student stuff. Do you know the answer to that?
So I would definitely double check this with the financial aid office, but I think generally in order to qualify for the AB 540, you have to have done high school here a certain number of years. So I'm not sure like if the person just came, you know, or or not. So they would need to check that.
I will share a link to how to qualify for AB 540 following this webinar, but it gives you several different options to qualify for in-state tuition and also how to apply for the DREAM Act. Is there a way for petitioners to check criminal records or get like a detailed history before they file a petition?
Yeah, so that's what I was talking about. A legal representative can help someone with this. In general, it's actually not the petitioner, the family member who already has immigration status, who needs help researching their record or their immigration history. It's the beneficiary, the person who is hoping to immigrate. The only exception to that is if the petitioner was convicted of certain crimes involving sexual abuse of minors, then they're not allowed to petition. I mean, this isn't super common. For the most part, the scrutiny is on the beneficiary, the person who's hoping to immigrate. And so for that person, they might want to submit what's called a Freedom of Information Act request, or sometimes it's referred to as a FOIA. And you have to submit one to every governmental agency, in this case, each of the immigration agencies that you think might have records on you. So you would have to submit one to CBP for Border Patrol if you think that there was something that might have happened at the border. You would also want to submit one to ICE if you think that ICE ever had any contact with you. And if you were in immigration court, you'd want to submit a third one to what's called the Executive Office of Immigration Review. So not that people can't do these on their own, but it might help to have a legal representative help you find the addresses and figure out what information you need to send. And those are free. They can take different amounts of time to get back the results. But yeah, that would be the way to find out what record you have.
Thank you. And can you speak about how someone's case can be potentially impacted if they were using somebody else's social security number?
So like if they were working with someone else's social is what I'm assuming we're talking about. So in general, it doesn't have a huge effect. It's better if it is like a made up or a fake social rather than someone else's, so you're not accused of like identity fraud, I think that's what it's called, right? And then as part of like that step 2, so after the family petition, when you're moving on to the green card application, people who are preference beneficiaries, so not immediate relatives, another way in which immediate relatives get sort of special treatment is if they worked without employment authorization, it wouldn't be a problem. But if you're a preference beneficiary, then working without employment authorization is a problem. So it's not quite the same as using someone else's social, but if you didn't have a work permit and you were working, that might disqualify you from that second step of applying for a green card. And, we talked about this a little bit before, but one of the ways to, move out of the preference categories and into the immediate relative category, which is, has some benefits, is if a LPR petitioner becomes a citizen, right? So it's not like you're stuck forever in a preference category.
Thank you. And one other question, if there are 26-year-old and their mother petitioned for them and they are a DACA recipient, is there like an estimated time frame or will they have to wait years?
Let's see, so they're a DACA recipient. How old are they?
26.
Oh, 26, and then
the petitioner was their mother.
And what was her status?
U.S. citizen.
And then are they married?
No.
The DACA recipient?
No, they're single.
Okay, so then I'm trying to think really quickly if I can pull up so the visa bulletin, right, has these wait lists, and we didn't want to go into too much detail on the categories, but so like an unmarried, over 21, child of a U.S. citizen is what's called the first preference category. So part of the wait also depends on what country they're from. Where is this DACA recipient? Where were they born?
I'm not sure.
Okay, well, let me just pull up the visa bulletin. I saw you sent the
So I have it up. I get.
Oh yeah, okay, yeah, sure. Veronica, I want to chime in.
Yeah, so it would be first preference category, we said, right?
Yeah.
So if they're from Mexico right now, they're reviewing petitions from September 22nd of 1997. So it depends, when their petition was filed. If it was recently filed, then they have quite a wait, right?
Yeah.
And for Mexico, if it was filed maybe when they were younger, the wait's less now. But yeah, or if they're from a country that's not heavily impacted, like, they're looking at petitions right now from January 1st of 2014. So
Yeah, for other countries. I'm
Yeah.
looking at here too now. So like if this DACA recipient were from China, then the wait is more like 6 years as opposed to the ridiculously long wait for Mexico. Philippines, the wait is more like 10 years. Yeah.
Okay. And can you touch a little bit on some options that individuals might have if they were brought here as a child but don't qualify for DACA?
Options in general?
Yeah, I mean, some of these might be a little too specific, and we can encourage them to seek out a legal service provider to ask these very specific questions.
I mean, I guess very broadly, we could say, apart from an option through a family petition, which was what we were focusing on today, there's the employer options or the diversity visa, which I mentioned very briefly. That's kind of like a lottery. You put your name in a hat and they might pull your name out and maybe you would be selected. But you have to be from countries that haven't had high rates of immigration in recent years. So these are like some countries from like South America, Asia, Africa. Also some other forms of relief, like there are visas for people who have been the victim of certain serious crimes. Or if they've been a victim of human trafficking, or if they fear returning to their home country because they fear persecution. There's asylum and some related forms of relief. Am I forgetting anything, Veronica? And some of the basic,
Yeah, no, I think that covers the most
categories,
common categories. I would just say that if some of these, like we mentioned with BAWA, they still require like a family relationship, but there's other options where the person who might have harmed you, you don't need that family relationship to look into, just in case that's, part of the facts of your case. Like if you've been a victim of a crime here in the United States, but you don't know who did the harm, that potentially won't stop you from moving forward, right? Also, if they're young enough, I don't know. I'm sorry if I missed the age of this person. Oh, but they didn't qualify for DACA, so they must be older than, or they could be younger, sorry. If they're under 21, potentially, and they don't have a relationship with their parents due to like abuse or neglect or something, they could always try to see if they would qualify for SIJS, right, which is available for minors, but that could be a little complicated. So I think the best thing is definitely to go and talk to someone about the specifics of your case and your life to see what would be available.
Yeah. I don't know if you have another question queued up, Alonzo, but I just saw there was one about whether COVID-19 is affecting any of this, and specifically the visa bulletin. So the visa bulletin that, sort of updating every month, who's at the front of the list, that has not been paused by everything else that's going on right now. And in terms of what we're talking about with submitting family petitions and green card applications based on family petitions, immigration is still accepting applications right now, but they're not doing any interviews and they're not doing any fingerprints, so any of the sort of in-person services. So if people already have pending applications, things are definitely slowing down right now and might be delayed if what you're waiting for is the interview. Not all family petitions have an interview. Usually the interviews when you get to the green card step, unless the family petition is a marriage petition, in which case they might want to sit down with both people and interview them about their relationship. Also, most immigration applications require someone to have their fingerprints taken. And so that's another thing that I was saying they're not doing right now because of COVID-19.
No, thank you. That was going to be the next question that I had queued up. There is another one about if they have two parents, does the USC submit one or two petitions?
So it's like an adult USC child who's going to be petitioning for their parents.
I'm going to assume so.
Yeah. Okay. And so like we were saying, they have that U.S. citizen child has to be at least 21, but then they would submit two petitions, one for each parent. One of the things that we were saying is like maybe the one downside to being immediate relative is like each person needs their own petition.
Perfect. Thank you.
Mm-hmm.
And this one from Josefina might still be a little too specific, but if she plans to petition her mother's status and received legal advice to request a FOIA to see if she was detained, can she request this information for her?
So can Josefina do the FOIA request?
Mm-hmm.
Yeah, she definitely can. I don't know if Veronica, you have on hand where to look up the FOIA information, but I'm sure like, right, a lot of these people, right, you guys are all in college, very smart. I'm sure you could figure it out on your own. You don't necessarily need a legal representative to do the FOIA request. I just wanted to note it is all caps, but it's FOIA. So you can Google FOIA, all caps, FOIA, and then what immigration agency, right, I was saying you'd want to request the FOIA from. So if they're wondering if she was detained, that sounds like maybe at the border. So that would be to CBP. If you're not sure, you can definitely just send it to as many of the agencies as you want because they're free. And if you were to Google FOIA and CBP and FOIA and ICE or whatever, you should be able to find the address where you mail it and details of what information they want. You can sort of do your own request where you sort of just summarize like, I'm requesting information about so-and-so person, give their full name and date of birth. They think that they had contact with immigration at the border near San Isidro in approximately June 1996. Please search for what records you have. A separate entity does these records requests. So we've never ever heard of anyone like triggering ICE enforcement action from submitting these requests. So they shouldn't be afraid to find out what information is out there because no one is going to act upon it. And then there's also a form that you can just fill out if that's easier than writing your own request.
Yeah, and a lot of these you could do online now, which is great, right? So you could just, like Ariel said, Google it and it should direct you to a government page where you could start a process for some of them. I think some are still just paper. But
and then one other thing I was actually going to add too is that so most of these are just based on you give them information like this is the person's name, this is when they think they had the contact roughly. It can just be an estimate. This is their date of birth as sort of just the identifying information. But there's another request called, the acronym is OBIM, which I think stands for like Office of Biometric Information. I don't know what the M is. Anyways, that one's based on fingerprints. So that one can also be good to do because, I mean, at this time, I guess with shelter in place, it may be challenging to get your fingerprints taken, but then you just send them in the fingerprints and that's what they use to pull up information.
Yeah, and just to mention in the line of fingerprints, though, it's harder if someone isn't in the country, right? And now because things are close, you could also try to do like an FBI request. They don't always show everything, but they do them really quickly. Like in 2 weeks, you could get like an idea of maybe what might be on a person's record for those of you who know someone who's maybe just wants an idea, right? And then see what other ones they would submit.
Great. Thank you for your presentation today. I found it super informative, and I'm sure our attendees today did as well. But we have reached the end of our allotted time for this webinar. If you have any further questions, please reach out to me. I will be following up with a recording of this webinar, as well as today's, as well as a PowerPoint and additional resources that were shared and discussed today. So I thank you both for your time, and I look forward to our future collaborations. Thank you, everybody.
Great, thank you.
Yeah.